Um, well, here we are again for the Davis case, and is Mr. Reed gonna be here this time? You're muted.
As far as I know, he's going to be here. He's the one who wanted the status conference.
Okay.
I can try and email him again and ask him where he is.
Well,
do it that way.
maybe sometimes this Zoom is kind of delayed.
Okay. I'm gonna call him while we're on the phone.
But you did such a good job last time of rousting him, so maybe do it again.
Yes, Bob, be there, please. Well, we're in the Zoom hearing waiting for him, so he hasn't shown up yet. Terry Jason. I think he's trying to get in, Judge.
Okay.
Hey, Bobby. You don't appear on the screen here. We have the bailiff, the court reporter, the court coordinator, the judge, and I. Can you see us? It says it's about to begin, Judge.
I'm sorry?
The screen that they have says it's about to begin.
Oh, maybe it's just trying to log in. Is he trying to log in under his name or someone else's name?
Sarah Jones.
That would explain it.
Here.
Okay. Yeah, I try not to let everybody in sometimes because it becomes kind of there's a lot of boxes.
Okay.
So
he's coming.
Well, if he had told me he had a name change, I would have known to let him in.
Well, yeah. Apparently, he's the one who has the good computer skills.
Yes. How's it going down there?
Bobby, you're muted. You're muted, Bobby.
Yeah. He's gonna go get Sarah Jones. He knows how to unmute.
Okay.
We can hear you now.
Good.
All right. Let's go on the record and cause number D19-28481-CV. This is a case Adam Davis versus Willie Davis, and I have counsel for both sides present. And this was set for a status hearing on this case, and I think Mr. Reed, you had asked for it to be set for a status. Is that correct?
That's correct, Your Honor.
Okay. Well, the floor is yours.
Okay, Your Honor, this is a partition suit that I have filed. It's a tract of land in Navarre County, around 200 acres. I really don't know exactly how many acres there are. There are multiple owners. I represent Adam Davis, who we contend owns a 1/8 interest in the property.
Okay.
We filed a partition suit, and it appears to me as though it would be beneficial to all concerned that the tracts that are the subject of the litigation be surveyed to determine the exact number of acres. And so that we would have a plat and some field notes. And then Thereafter, we would be able to sit down and try to negotiate some sort of a settlement as far as a partition of specific tracts. And if not, then the court would appoint commissioners. And of course, obviously the court and I think the commissioners would need to know the total number of acres with which we're dealing so as to determine the appropriate division of the property. The code, I know that you know better than I, but the code says the court.
Not really.
Okay, well, I can put it, but the code says that the court can appoint a surveyor and in connection with this matter. Mr. Jacobs and I talked, we've tentatively agreed on the surveyor, I think.
Okay.
And we agreed on the surveyor, but the question is money. The surveyor, I believe, will require a deposit for the survey. And we're willing to deposit our portion. And we're asking that the court order all parties to deposit their pro rata part of the anticipated cost of the survey so that this case could proceed.
Okay.
Sole purpose of the hearing.
Yeah, I know in an unrelated case, Mr. Jacobson was part of it. We had a hard time finding surveyors at the time, but hopefully that's not the case here. Mr. Jacobson?
Yeah, Judge. It is a partition suit. I represent I guess it'd be the aunts and the uncles of Mr. Reed's client, I believe, would be the appropriate familial relationship. We're okay with the court appointing a surveyor. However, we believe that the survey cost should be split 50-50 as opposed to pro rata. My clients don't have a lot of money, number one. Number two, they're perfectly okay leaving the property the way that it is. Mr. Reed's client is the one who requested the partition. And as such, he had to bear at least half the expense of the survey.
Okay.
Your Honor,
So that,
Mr. Jacobson and I talked about, I think we agreed tentatively on Eric Sanford as a surveyor. That really is not pertinent, I don't guess, to what we're doing. But my client owns a 1/8 interest. And to me, fairness would provide that my client should pay 1/8 of the cost, his pro rata cost, share of the cost of the expense of the survey. I mean, we have the right to a partition and we should bear our pro rata part and they should pay their pro rata part, Your Honor.
We're happy with the way things are. Everybody just owning undivided. We're perfectly okay with that. We don't need the expense of a surveyor. Your client's the one who filed the partition suit, and we think fairness. Of course, I think fairness is different than Bobby thinks fairness is, but fairness would require him to bear at least 50% of the cost because he's the one who brought the suit.
And Your Honor, we own 1/8 of the property, so we should pay our pro rata part. And that's just our position now.
I echo what I just said, but I think the court probably has a pretty good idea of where the lines are drawn on this one.
And so that's all I have, Your Honor.
okay. Is this cost that something could be recouped at the end of this case?
No.
No, sir.
No.
My client needs the survey. He wants to build a house on his portion of the property. And of course, he cannot do that until his portion is designated and can't borrow any money until his portion is designated. But there's no sale to my knowledge, and there's no recoupment per se.
Do you know if there's been an estimate of how much the survey would cost?
Judge, I'm not, no, not to my knowledge. A couple $100, I'm going to guess it would be, Terry, this is entirely speculation on my part. I would guess it'd be in the neighborhood of $5,000.
I have no way of knowing if that's right or wrong. The tract is rectangular, bordered on two sides by county road. It's actually relatively flat. So if that makes a difference in what the cost of a survey is, then it's probably easier to survey this than some other tract that's deep in the woods somewhere. But I don't know, Judge. Don't know.
Right.
All right. I guess I think y'all made your points. I'll order that each side pay half, and just give me an order to that effect.
Okay.
All right. That concludes.
Bobby, let me call you in a minute. We'll agree on a surveyor. How's that?
That'll be fine. Okay.
Thank y'all.
Thank y'all.
Thank you, Judge.
Thank you,
Have a
Judge.
good day.
You too. Do we have everybody present on Naranchus?
We have a caseworker judge. We have, I'm losing track of who's involved.
We got
Ms.
Miss.
Bassett, you're on the,
Yeah, we got Miss
Yes.
Basnet present. Kelly Myers is present. Demara Watkins is present. You're present. Casa. So what about Miss Basnet? Is your client present?
No, Judge, she's not. She just finally got moved to the Martin unit, and she is engaged in a 6-month program for her release on parole. So I didn't want to interfere in that.
Gotcha. Mr. Myers, your counsel for the father. Last time I remember, he was in the detention facility on an immigration, or I don't know what we call it, ICE hold. Was that correct in Johnson County, or am I?
That's correct, Judge, but he was recently released because I guess the current administration is not really enforcing deportation, number one, and number two, the country of Palau indicated that they have COVID restrictions and he would not be allowed there, so they just released him. I went through my file. I just found this out yesterday because Christian was nice enough to call me and tell me. And he was in jail when I was appointed. And so I have not a single phone number to contact him. He's been continuously incarcerated until he was just recently released. So I have no address and no phone number. Anytime I needed to see him, he was in jail.
Okay.
So I have no way to contact him, and I don't know if anybody else has any knowledge of his whereabouts.
Well, does anybody
Judge, I know,
get started?
Judge, I was going to say, I know we don't know where he is. We just found out that he was released. We just found that out this week. And he was apparently released sometime last week and just released on the street. And I've contacted the DA's office because the way I look at the case, he was sentenced to he was on a probation and then sentenced to go to Safe P with TDC, but he did not, that was never executed, or he didn't go into that because he was immediately taken into the federal hold and has remained there until apparently last week. And so I've contacted the DA's office just to raise this issue with them and with probation that it appears to me that he's still under that sentence. But he's on the ground right now, and I don't know what the status is in terms of him reporting to anyone. He wasn't, he's only under any prior orders. There's not any new orders that have been entered with respect to him being released. The feds didn't bother to let anybody know about this until we called and tried to see his status. I believe CPS has a phone number or two of a couple of local relatives who were being considered or were at one time stepped up to try to seek placement, but they no longer answer their phone calls. So we don't know any more than what I've just said.
Well, all right. I guess that I'll well, we can go ahead and start. I don't know who you call when these things happen. I have if people are just released without any date to come back, I have a feeling I know what happens. People just disappear. So I'm not saying about this, but just in general, there's no no count. Well, all right, let's get started, and maybe someone can figure out who to call and find out from the federal side what happens on cases like this. But I'm not sure. I've watched enough and read enough that it seems like it's just people are being released and with no date ever set to come back to court. So to the immigration courts. Maybe y'all can call somebody at the White House and see if they know. All right, we'll go on the record in D19-28143-CV in the interest of the Naranchus children. And I've had a hard time this whole case saying that name, and I continue with that. The department is present, represented by Randall Means. CASA's present. The mother is present through her attorney, Ashley Basnet, which Ms. Basnet, prior to going on the record, indicated that her client is in a program, and a TDC program. Is that correct, Ms. Basnet?
Yes, Your Honor.
Okay, and you did not want her to be disturbed in that program, which I certainly understand. Mr. Myers, you've indicated prior to going on the record that your client was in custody with ICE and has since been released, and you do not have any way of contacting him at this time. Is that correct?
Your Honor.
Ms. Watkins, you're here as the attorney ad litem for the children. And then I guess this is a permanency hearing before a final order. And I know the last time we were here on this case, there was a jury trial setting back in January, January, February, and it was canceled due to COVID. And with that, I will turn it over to Mr. Means to call his first witness.
Your Honor, I have two witnesses, I believe, that can be sworn at one time, Christian Daniels and Kay Smith.
Okay.
And let me ask, is there, Ms. Gallagher, is there a second CASA testimony? Because I believe Ms. Smith is only aware of placement of part of the children.
There is. It's Mike Cord, but I don't see him on. I'm trying to contact him.
All right.
I'll go ahead
Thank
and
you.
swear.
Judge, I'll proceed with Ms. Daniels and Ms. Smith.
Y'all want to raise your right hands. Do each of you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
You may proceed.
I will call Christian Daniels. Ms. Daniels, are you the CPS caseworker assigned to this case involving the Garrett Karanja's children?
Yes.
And what sort of placement are the children in at this time?
They're all in foster care in foster homes.
And I believe there are 8 children involved, and are they spread in 3 different homes? Is that correct?
They're all in 4 different homes.
I'm sorry. And can we sum up all the children together, how they're all doing in their placement?
All of them are doing pretty well. We don't have any concerns right now. Alicia just turned 16. She's looking forward to working. Annalani, Chloe are doing well. They're together. O'Neill and Kara are looking forward to Disney this summer. And then McNeil, Abigail, and Kimura are together. McNeil was considered for GT, and Kimura and Abigail are doing well as well in that home.
And you mentioned McNeil and GT. Can you explain what that is?
Gifted and talented. They wanted to consider him, but due to his behaviors, I think that they're gonna wait to see if that changes. But he's pretty smart, so they're.
And just to be clear, I'm sorry to interrupt you. Okay, so with respect to that particular thing, is that a disciplinary issue that he has in school? Anything unique about that?
Well, he has some behavior issues, so they said that they're gonna wait as far as the program goes to put him in gifted and talented. I think when he's told no or he wants to do something that he's not allowed to do, he decides that he's gonna wet himself and just become defiant. So they said that he wasn't eligible for the program at this time.
With respect to all of the children, are any of the children receiving counseling at this time?
Yes, all of the children receive counseling.
And does that include McNeil and his special issues that you mentioned?
Yes.
Is there any need for any additional services to be provided to any of the children with respect to their counseling or with respect to this particular issue you've mentioned about McNeil?
No, not at this time.
Are all of their medical needs being met at this time in their current placement?
Yes.
Is there have medical professionals been consulted on the children, and is there a medical plan in place for all 8 of the children?
Yes.
Does the department recommend that their current placement is meeting their needs and is there in their best interest?
Yes.
Do you recommend that the placement continue for all of the children?
Yes.
How about the children doing on sibling visits? How is that being handled at this time?
They still visit with us at the CPS office, and their visits go really well. I believe one of the children or a couple of them couldn't come because STAR testing is going on for a couple of weeks. So it's like a hit and miss, but they do really well at the visits. They enjoy each other.
Now, with respect to the father, we've heard about him being in custody, so I assume there's been no visitation there. Since the mother has been in custody in TDC, has there been any visitation available there through any sort of remote facility at all?
No, she's able to write letters, and the kids give me their letters to write her back. So we just been doing that. They've been communicating that way.
So the department has maintained that connection between the mother and the children?
Yes.
Does the department have any information as to a current parole date for Ms. Scott?
I've called the current prison that she's at, and they stated that once she's completed her 6-month program, then she'll be given a date to be released.
Do you know if she started that program yet?
As of yesterday, she has not started the program because they have, I guess they haven't put her in the program yet. Her time hasn't came. It's not anything due to her not signing up. It's just her time hasn't come for her to be placed in the program.
Had Ms. Scott completed any of her services before she went into TDC?
She did her psychosocial assessment. I believe she completed her substance abuse assessment, and she started her counseling.
And has the department had any contact and any response from the father, any services that he ever did before?
No.
Now?
No.
And he was from the time this case started until he was just released last week, from what we've been told, he has been incarcerated during that entire time. Is that right?
That's correct.
Based on the current status of the parents and their ability to provide a safe environment for the children, do you recommend that children continue to need substitute care?
Yes.
Your Honor, I pass the witness.
Bassett, any questions of this witness?
Yes, Your Honor. Ms. Daniels, can you hear me okay?
Yes.
Prior to, well, I guess let's start with when my client was incarcerated in Navarre County, was she having visitation with Alicia?
Yes.
And how often was that?
I believe we would do every other week.
And was she also able to call in and speak with the other children during their sibling visits?
Yes.
And did that change when she was moved from Navarre County Jail?
Yes.
You recall where she moved to at that point?
I believe it was Plain Jail. It's called Plain Jail, but it's a prison facility.
Okay. And visitation could not take place while she was there, is that correct?
That's correct.
And then she's been moved, I think, twice since then and is now in the Martin unit, is that correct?
In the Marlin unit?
Marlin.
Yes.
Yes. Thank you. Have you been made aware that in-person visitation could take place at her current unit?
Yes, and I also called them and I spoke with them the week before last, and they stated that only one adult could come. And so I asked, could I bring Alicia, who had just turned 16, and they told me that no, because they're only allowing one adult.
So they're considering Alicia to be an adult.
Well, they said that they're only allowing one person, so
Okay.
I couldn't bring another person.
And I'm assuming that's not allowed by CPS to let Alicia, go in and talk with her mother unsupervised by CPS.
Right.
Has there been any efforts to reinstate the telephone calls between mom and the children during their sibling visits?
Yes. So I've called and tried to set up. Your client sent me the paperwork in order to set up my phone number. I tried to set it up, and the operator stated that since the phone did not belong to me personally, then I couldn't set up my number to be on her list. So
And oh, go ahead.
I would have to have a personal number that belonged to me that I can show proof of.
So for clarification purposes, the phone number you were providing is your work cell phone, correct?
Yes.
And CPS policy and just you personally, you do not give out your personal cell phone to any.
That's correct.
Do you know if there is any other person that is willing to step forward and allow their personal cell phone to be used during the sibling visits?
This time, I don't think CASA would like that.
Is there any way we could allow a family member to be in the visits and use their cell phone?
Yes, if a family member wants to come and she can call their phone, that's fine.
And you had stated that your understanding is that my client, in order to be released, needs to complete a 6-month program.
Yes.
Are you aware of what all that program entails?
When I spoke with Miss Scarborough, she told me a little bit about the program, but she didn't go into detail.
Is my client engaging in that program going to be counted as working on services or making progress in this case?
If it's the program that she told me about, I think it was called Choices. That program counts as our substance abuse part of the services, so she would get credit for that.
Okay. And just to has my client informed you that she intends to try to get her GED before she is released?
Yes.
And is that something that the department would give her credit towards as far as making appropriate choices for being able to provide a safe and stable environment for her children?
Yes.
Prior to her being in her current unit, were there issues with getting services set up and available for her in her previous units?
I believe so. She was going to start services there, but then COVID happened, so everything was shut down.
And when she was transferred to prison, was there any time to get any services in place for her to start initiating?
No, I think she got COVID as soon as she got transferred.
Any services that you have set up for her while she's been incarcerated, has she worked those services?
Yes, she has worked through counseling, but she was not able to complete it.
And what was the reason for that?
She got transferred to prison.
Do you know if there's any additional services that you can set up for her outside of the 6-month program that she's engaged in or will be engaged in at her unit?
I can look into it, and I can also get with their education department to see what all they offer as well.
I pass the witness.
Mr. Myers,
No questions, Your Honor.
Ms. Watkins,
No questions, Your Honor.
Mr. Means, anything further?
Yes, Your Honor, one clarification. Ms. Daniels, You just mentioned that she was going to start services and then COVID shut everything down. What stage of the process are you talking about that occurred? I wasn't clear as to at what point from her being in Navarro jail versus TDC versus any of the units in TDC. Where along that process were you talking about?
When she got to TDC, she stated that she was going to start working her services there. She was going to start a choices program at that prison, but then everything was shut down due to COVID. Their numbers were too high, so they were no longer having any classes.
And so when you say going to working her services, the service that she was going to try to attempt was the single service you've described as the choices program. Is that right?
Yes.
That's all I have, Your Honor.
All right, Ms. Bassnett,
Nothing further, Judge.
Mr. Myers, or Ms. Watkins?
No questions, Your Honor.
Nothing, Your Honor.
Okay. You may call your next witness.
I don't call Kay Smith.
All right, you may proceed.
Ms. Smith, are you? Thank you, Judge. Ms. Smith, are you the CASA volunteer currently assigned to the some of the children involved in this case?
I am. Yes.
And how many of the children are you dealing with?
5.
Which ones?
Kara,
And which
Chloe,
ones?
Kara, O'Neill, Chloe, and Alani, and Alicia.
Okay, I'm sorry. And how, from CASA's point of view, how are those 5 children doing in their current placements?
They're doing well in their current placements.
How often are you able to see any of the children? I believe from what you've described, it looks like that's 3 different separate placements you have to deal with.
I visited Karen O'Neill on the 27th, Chloe and Alani on the 27th of this month of April. And then I talked with Alicia last night. And then I see them at their visits every other Thursday.
And Alicia is the oldest. She's in a placement by herself. Is that correct? Or at least away from the other siblings?
That's correct.
Do you recommend that there's any changes that need to be made, any further services provided for any of those 5 children from CASA's point of view?
Not at this time.
Do you recommend that their current placement is in? Do you recommend their current placement is in their best interest and should continue?
Yes.
Your Honor, I pass the witness.
Ms. Bassnett, any questions?
No, Your Honor.
Mr. Myers
No, Your Honor.
or Ms. Watkins?
No, Your Honor.
All right, you may call your next witness.
Your Honor, I'll call Michael Cord. He has not been sworn. He's on the screen there.
Yes, Mr. Cord, if you could raise your right hand, do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
All right, you may proceed.
Mr. Cord, are you the second CASA volunteer that's working with, I guess, 3 of the remaining children in this case?
Yes, I am.
And how often are you able to see the children and how are they doing from your point of view?
I see the children a couple every other week, and then at home visits, and when I go to the school to check on how they're doing.
And how are all 3 of the children doing from CASA's point of view?
Abigail and Kamora are doing very well. We have some problems with McNeil. I had gone to the school and asked that he be tested for talented and gifted program. He was accepted in that program, but because of his behavioral issue, he was not allowed to participate in it. And that is a concern of mine. It's a behavioral problem, not an intellectual problem.
are you aware, are you recommending anything be done and anything initially that's, or in addition rather, that's not being provided to McNeil yet to try to address those issues?
Yes, he is currently seeing a counselor, but I would think a behavioral psychologist would be useful in this area for him.
Do you know, I'm sorry, do you know if his current counseling is at the face-to-face or is that virtual?
No, it's face-to-face.
As we're doing now.
It's face-to-face, and they're using a token economy system, which is generally pretty good. The foster parent does well with it, but his reward is when he becomes angry, he does what he does, and that is stronger than his wanting the reward that's been offered.
From CASA's point of view, do you recommend that their current placement for all three of those children remain as it is?
Oh, yeah. Yes, I do.
And McNeil, Alani, and the three younger children, they're all together in the same placement, is that right?
Yes, they are.
And just the final question, do you believe that placement is in the children's best interest at this time?
Yes, I do.
Your Honor, I pass the witness.
Ms. Basnet, any questions for this witness?
No, Your Honor.
Mr. Myers,
No questions, Your Honor.
and finally, Ms. Watkins.
No, Your Honor.
All right. Any other witnesses? Mr. Means, before I turn it over to Ms. Basnet?
No, Your Honor, I rest.
Okay. Ms. Basnet, do you have any witnesses to call?
No, Your Honor, we rest.
All right. Mr. Myers
No witnesses, Your Honor.
and Ms. Watkins.
No witnesses, Judge.
Before we go any further, again, this case was set for jury trial. Is that where it needs to remain?
Yes, Your Honor.
Okay. I know y'all been to mediation for at least once. There may be more, but okay, we'll get a setting. I think we're working on that for June. So the court will make a
Your
finding.
Honor, I believe
Yes, sir.
I just had a question about the trial setting, Judge, but I'll let the court
For August
continue. Sorry.
23rd for jury trial.
Oh, August 23rd.
Yes,
Okay.
sir. They got a scheduling order and then pretrial August 19th at 9.
Okay. All right. So at this time, the court
That's
will
what I
make
was
a
going to raise, Judge.
Yeah, thank you. Yeah, usually I'm not very good about knowing scheduling, so I shouldn't even said the date or month, much less the year. So I'll make a finding at this time the current orders in effect are in the best interest of the children, and hopefully the parents can get into a position where they're able to take advantage of the services that are being offered. I know that some are not able to be taken advantage of or to be utilized based on the mother's incarceration. As far as the father, hopefully he will exercise some diligence in trying to contact the department and or his attorney. So with that, I'll sign an order when it's presented. That concludes this hearing.
Thank you, Your Honor.
Thank you. Okay, the next one I have is Jones. I didn't see Mr. Green on here unless he is, and I'm not.
Judge, I can speak to that. I submitted a proposed order to him with the case on the testimony we expected, and he signed the order and sent it back and said that he would not be attending this morning. I believe he has a conflict that he can be yanked out of if necessary, but so that's the status. He does not intend to appear, and he has agreed to the orders that we have proposed, which is basically to continue the current placement.
Okay, well, we won't yank him. We'd like to sometimes, I know, but we won't to this morning. Okay. We will go on the record and cause number 11-20403-CV in the interest of Carly Gail Jones. And I have the department present, represented by Randall Means. CASA is present. parental rights have been terminated, and Neil Green is the attorney ad litem for the child, and it's my understanding that Mr. Green has agreed to the current placement, current orders in effect. And before we get started, how old is Carly at this point? Is she
Carly will be 17
Judge, she's
on the
16.
13th.
okay?
Yeah.
So she's 16, will soon be 17. Okay.
She'll be 17 in 2 days.
All right. Well, okay. With that, I guess I'm assuming Mr. Means you're going to call Miss Thomas since she spoke up, and Alex Smiley and Jenny Bratton possibly. I'm just going who you called last.
Just Alex, Judge. He was,
Okay. So Miss Thomas and
right.
Mr.
We'll call Tina Thomas.
Okay.
Yeah.
Y'all want to raise your right hands? Do each of you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Call Tina Thomas. Ms. Thomas, are you the CPS caseworker assigned to the case involving the child Carly Jones?
I am.
And what sort of placement is Carly in at this time?
She's in a general residential center go ahead. I apologize.
Is this basically an RTC and she's in a unit or a division of the RTC?
Yes, it's a step down from the RTC.
Step down as in less restrictive or step down
Yes,
as in
correct.
less services? What do you mean?
Yes, it's less restrictive.
How is she doing in her placement?
Carly's doing really well. She's made significant progress since she's been in the placement. She's participating in public school. She's doing life skills in school. She's working in her therapy, making a lot of progress in her therapy. She's come a long ways in her treatment for her health. So Carly's just really made a lot of progress where she's at.
Now, to summarize, she came into the CPS care during a time when her mother was basically contacted CPS and was not able to provide the care that Carly needed and was not able to basically to manage the situation she was dealing with. Is that a fair summary?
Yes.
And since then, her parental rights were terminated and she's been in CPS care since that time. Is that right?
Correct.
What is the current plan for Carly and her mother?
We're looking at doing a relative conservatorship and a monitored return to Carly for her mom. And we're working on getting that approved by the department.
And what's been involved in that? Has that required changes or improvements by her mother in her current living situation in her home, et cetera?
Yes, mom had, excuse me, mom had some significant things that she needed to work on to make progress to get ready for Carly. And mom has been working on those things. So she had to prepare a space for Carly in her home. She's needed to learn about Carly's medical issues and her behavioral concerns and the things that it would need to treat those. So mom's been working on visiting with Carly, getting to know Carly, reestablish a relationship with her. And mom's been making adjustments for all of that to prepare.
The report you filed with the court provides the description of the medical issues that Carly has to deal with and her diagnosis. Is that right?
Yes, it does.
And does all of those various medical issues that she has to deal with, does that require or has that required special training and special knowledge for her mother to be prepared to deal with those issues going forward as Carly remains in the home with her?
Well, what we've done with her mom is have her speak with the Carly's the staff that works with Carly with her medical issues. And mom has had to get a little bit of education and then talk to doctors and know what it's going to take to prepare for medical appointments and physical therapies and those things moving forward. So yes, she has needed the education.
And has her mother demonstrated an interest and cooperated with that and tried to proceed toward the goal of reunification with her daughter?
She has.
Is she currently able to, at this time, as of today, to provide a safe environment for the child, or are you recommending that the placement continue until the department has completed the process?
We're recommending that the placement continue while we continue the process of getting it approved. We didn't want to move forward too fast and set mom up. We want to make sure that everything is ready for her and Carly.
And by set mom up, you mean set her up for a failure before in moving the child before everybody was fully ready and the child was ready for the move?
Correct.
And until that is completed, do you recommend that the current placement is in the child's best interest?
I do.
Are there any additional services that need to be provided to either the mother or Carly right now to facilitate the process? Or are you satisfied that the services the department is providing at this time is what everyone needs?
The department is satisfied right now that everyone has what they need.
And to be clear, I think you've already said it, but the permanency goal right now is to reach the relative placement, in effect, placing her back with her mother.
Correct.
I mentioned all of her medical issues. Are all of her medical needs currently being met and addressed in her current placement? And is there a plan in place? And do you recommend the court accept the plan and the treatment she's receiving?
Yes.
Your Honor, I pass the witness.
All right, you may call your next witness.
I call Alex Smiley.
All right, you may proceed.
Mr. Smiley, are you the CASA volunteer assigned to the case involving Carly Jones?
I am.
And I believe I may be having some internet instability here. I'm getting some flash message on it. So someone wave at me if you can't hear me. Mr. Smiley, what is CASA's point of view in terms of the how Carly's doing in her current placement?
I actually saw Carly this Saturday. She's doing extremely well. She's communicating better than she ever has. The placement has been amazing for her in both the development and growth areas of even like social interactions. And it continues to improve over time. And I think it's been great. It's very good for her.
Have you heard the recommendation from the CPS with respect to the goal or the objective of the child eventually being placed with their mother when everybody's all set for that to proceed successfully?
Yes, I have.
What is CASA's point of view about that goal?
We are in support of that goal. Look forward to it occurring. Ideally, as I would like to see this happen before the beginning of the coming school year, as a result of the fact of making that transition as smooth as possible. I know that Ms. Thomas has also said that she would like to see that be the ideal timeline so that we can make that transition and not have any kind of problems as the school year starts in one space and then her having to move and transition to a new school in the middle of the year.
Does CASA concur in the intent that Ms. Thomas mentioned about the idea of not moving the child too soon until the mother is fully ready to avoid the risk of anything going wrong because the mother's faced with that responsibility before she's fully ready?
Yes, we also understand, and that is to be kept in balance with obviously the goal of having her there before the beginning of the school year. Don't want to move her too soon, but as soon as we can.
Does CASA recommend that the current placement is in the child's best interest until the move can successfully be completed?
Yes.
Your Honor, I pass the witness, and I have no further witnesses.
Okay. At this point, the court will make a finding that the current orders in effect are in the best interest of the child, and I will sign an order to that effect when it's presented. That concludes this hearing. Okay. The next one we have is Ortega. Who is our new ad litem for the child?
Judge, I'm not aware of one being appointed
Okay,
since the withdrawal.
that probably needs to occur pretty quickly, but we'll okay. This is cause number D20-28949-CV in the interest of Elijah Joel Ortega, a child. I have Randall Means present for the department. CASA is present. The father is present through counsel of record, Ms. Demara Watkins. The mother is present through her attorney, Ashley Basnett.
Judge, my client is present.
Okay. And is she on Marissa's iPhone?
Yes,
I'm
Your Honor.
Okay. All right. And this is a second permanency hearing, is that correct?
Yes, Your Honor.
All right, you may proceed.
Your Honor, I have two witnesses to be sworn at the same time, Erica Kincaid and Melinda Veltman.
Okay. If y'all want to raise
They're
your
both
right,
on screen.
each of you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God.
Yes.
Can you
Yes.
Gotcha, thank you. All right, you may proceed.
I'll call Erica Kincaid, Your Honor.
Okay.
Ms. Kincaid, are you the CASA, the CPS caseworker currently assigned the case involving the child, Elijah Ortega?
Yes.
And what sort of placement is the child in at this time?
He's in a foster home placement.
And how is he doing in his current placement?
All of his needs are currently being met in his placement. He does have significant medical needs, but all of his needs are being met.
And has he been in this placement since he was released from the hospital?
Yes, he
when
has.
he was removed?
Yes.
And is this a placement, I'm sorry, and does this particular placement have a long history of experience with the department with working with infants with special problems like this?
Yes.
And the child has a long list of medical needs, is that right?
Yes, he does.
And are all of those needs being met in the current placement?
Yes.
Is there a medical plan in place, and do you recommend that the court accept that plan?
Yes.
And you recommend that the current placement is in the child's best interest and needs to continue?
Yes.
Now, at this time, are either one of the parents able to provide a safe environment for the child?
No, they are not.
So deal with the parents at one time at this time. What sort of services has the mother completed at this point, if any?
She has not completed any services. She did start individual counseling, but she discontinued her services. And she has completed her psychosocial, but she's not followed through with the recommendations.
Now, was the recommendation of the psychosocial assessment to participate in individual counseling?
Yes.
Did the recommendation also include anger management and parenting as two additional services?
Yes.
Now, you indicated she started individual counseling, but discontinued that. Was that her action, or was she discharged from the counseling? What was that?
She discontinued services herself without completing them.
What about her living situation? Has she provided any confirmation to the department as to where she's living?
She stated that she is living with her mother, but I've been given information from relatives that she may be living elsewhere, and I've not been able to confirm that she is actually at that residence.
How about her employment? Has she ever provided any confirmation for her employment?
She did tell me that she was working previously at Russell Stover, and I did confirm that she had been employed there. Recently, she stated that she has been working for relatives, and she has not provided documentation of that.
How about visitation? Is she engaging in visitation with the child?
She has been very sporadic in visiting.
Can you give the court an idea of how many visits she's had and how many visits she's missed or failed to attend?
Since January, there have been 18 visits that were offered, and she has canceled or not shown up for 13 of those visits. And she's only visited in person twice, I believe. I'm sorry, she's visited in person 3 times and twice virtually.
And the child is currently an infant, right?
I'm sorry?
The child is an infant, is that correct?
Yes, he is.
The visitation, is it within the same city or the same general area where the mother claims to reside?
No, it is in the same vicinity as the child.
Well, what I'm trying to get to, and I may be misunderstanding, is there anything special about that makes it difficult for the mother to reach the location where the visitation can occur with the child?
No.
In other words, it's not an extra long distance she has to travel from Corsicana to Dallas or that sort of thing, correct?
It's about an hour drive.
Okay. Does Ms. Macias have any criminal charges pending?
Yes, she does.
And is that in Navarro County?
Yes.
And is that associated with the facts that have brought the child into care?
Yes.
Do you recommend that with respect to the father, has he completed any of the services that he was required under the plan?
He has completed the psychosocial evaluation, but has not followed through with the recommendations. He did start counseling and parenting classes, but was not able to complete those and discharged himself from counseling.
All right, when you say not able to complete those, so with respect to the counseling, was there something that prevented him from engaging in the counseling, or did he simply
He discontinued the services.
fail to continue? What's the status of that?
He discontinued them.
I'm sorry?
He discontinued the services.
Did he give any reason for that to indicate that there was something preventing him from cooperating with the services?
No.
With respect to the parenting, you say he started that. Did he voluntarily or apparently just stop that on his own as well?
Yes.
Now, from a psychosocial recommendation, was there anything recommended for him to, you've indicated individual counseling and parenting. Was there anything else recommended that he participate in from the assessment?
Anger management classes.
And has he started or done anything with respect to that service at all?
No.
What about his living situation? What information has he provided the department about where he's living?
He has reported that he is living with his mother. However, I've made several attempts to go by his residence at his mother's and have been unable to locate him there.
How about his employment?
He reported that he previously worked at Russell Stover, and I was able to verify that at one point he was working there, but he is no longer working there, and he stated that he is working for an uncle, but he has not provided information to verify that employment.
And how about visitation by the father? Has he engaged in that at all?
He has engaged in 2 in-person visits since January, and then 2 virtual visits.
And you mentioned, all right, you mentioned that there were 18 provided or made available for the mother. Were the same 18 available for the father as well?
Yes.
Do you recommend that the current placement of the child continue in the child's best interest?
Yes.
Your Honor, I pass the witness.
That's it.
No questions, Your Honor.
Ms. Watkins?
No questions, Your Honor.
All right. May I call your next witness?
Call Melinda Veldman.
All right, you may proceed.
Ms. Veldman, are you the CASA volunteer assigned to the case involving the child Elijah Ortega?
I am.
And how is the child doing in his placement from CASA's point of view?
He's doing well. He's starting to make improvements, both physically and in engaging with those around him.
And do you recommend any changes need to be made with respect to the services being provided to the caregiver or for the child in his current placement?
No, he has a battery of appointments and therapies that he engages in that helps with this improvement along. And I do believe that the foster mother is getting all the medical and physical therapy assistance that she needs now to care for him.
Do you recommend that his current placement continue and that it is in his best interest?
Yes, I do.
Your Honor, I pass the witness.
Ms. Basin, any questions of this witness
No, Your Honor.
or Ms. Watkins?
No, Your Honor.
Any other witnesses from the department before I allow Ms. Basnet or Ms. Watkins to call any witnesses?
No, Your Honor.
All right. Ms. Basnet or Ms. Watkins, any witnesses?
No, Your Honor.
No, Your Honor.
Okay. I need to make sure we get the child an attorney. Current orders will remain in effect, and we'll find that they are in the best interest of the child, and obviously the mother knows what's required of her to Miss Marissa, can you hear me?
Yes, sir.
Okay. And you understand that there's orders in effect, and that unless you're able to provide your child with a safe and or stable environment, your parental rights may be subject to restriction and or to termination. Do you understand that?
Yes, sir.
Okay. With that.
Your Honor, if I could, Your Honor, Your Honor, can I interrupt the court? I'm sorry.
Yes, sir.
Your Honor, I would ask to briefly reopen if I could.
Okay.
Before the court proceeds.
Yes, sir. Any
I would
objection?
call on Marissa Macias.
This is she.
Your Honor, I do object to reopening this. We've already rested and closed.
Mr. Means, what issue are you wanting to explore?
Your Honor, it's my understanding that Ms. Macias is pregnant, and we'd like to make a determination as to her expected due date and some facts about that. I believe that's a seriously weighs on the case.
Your Honor, that's not relevant to the matter that's before the court. The department's more than able to do its own investigation if it would like to do so.
If we're allowed to interview Ms. Macias, that's fine, but I don't know that that's been allowed. That's what the purpose of this hearing is.
I'll sustain the objection. Again, court will make findings that it's in the best interest of this child, and give me an order and I'll sign it. That concludes this hearing.
Thank you, Your Honor.
Thank you.
Thank you.
Judge, before I leave, I just wanted to confirm that you've been notified that the McCain hearing at 1:30 has been removed from the docket.
Yeah, the one is it 1:30 or 11:30? Did you? What
It looks
time?
like 11:30.
Yeah. Yes, I did get notification.
Okay, thank you, Judge. May I be excused?
Yes, ma'am.
Thank you.
Sorry to do a drive-by on your house the other day, wishing you happy Mother's Day, but I couldn't help it.
No, it was very nice. I appreciate
That was me. You were probably wondering, should you call the police or not, but that was me. That's what happens when I'm driving down the street with the window open. So,
We were able to see it was you. We're just glad our house looks a little bit better than it used to while people drive by.
no, I've been monitoring. I watch your husband. He's always in the yard standing there looking at something. So he looks like he's very busy.
He would rather be out there than anywhere else. And yeah, there's a lot of staring.
Well, sometimes that's what it takes. You got to go out and stare it down, and then maybe the problem will disappear. But
He would like to think so. So hopefully that's true.
okay. Well, have a
Thank
good day, all of y'all, and be safe.
Thank you.
Do we have everyone present on the 10 a.m. before we get started? Mr. York, I know I see him, and how you doing?
Are you Judge?
Your client is present. Is that Mr. Myers, Bradley Myers?
Yes.
Okay. Do we need to have anybody's name called? I know that was it Domingue was here last time, representing herself?
Yes, Your Honor. And she was provided notice of this through the e-filing system. Bradley, did you talk to her?
I tried calling her yesterday and didn't get a response.
So yes, sir. I guess we need to have her name called.
Okay, and it is Brooke Domingue?
Yes, sir.
And I'll make sure and put it on the record what time it is and everything. So do you want to call her name? Brooke Domingue? Is that how you say her last name, Domingue?
I believe so. It's not my last name.
That makes sense. Brooke Domingue. All right, we'll go on the record in D228864-CV in the interest of Damian Scott Myers, a child. I have the counter, I think, if I recall, Mr. York, you're present representing Mr. Myers, Bradley Myers, who was a counter petitioner in this suit. The petitioner's name has been called 3 times, Ms. Domingue. There's been no response from her. It's now 10:03 a.m. and there are no individuals or participants in the Zoom waiting room, nor has anyone responded outside the courtroom. So with that, I guess I'll turn it over to you. I can take judicial notice of the court's file and previous testimony offered, and you can call your first witness.
Yes, sir. I'll call Bradley Myers, please.
Okay. Mr. Myers, if you want to raise your right hand, do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, you may proceed.
Thank you, Judge. Bradley, state your name, please.
Bradley Myers.
And where do you live, Bradley?
Just outside of Albuquerque, New Mexico, Cedar Crest, New Mexico.
And who lives there with you?
Yes, sir.
I said, who lives there with you?
Oh, sorry. Currently, Damian Myers and my fiance, Cassandra.
Okay. How long has Damian lived with you?
Since May of last year. So
All
May
right.
2020.
How old is he now?
He's 7, about to turn 8.
Okay. Is he enrolled in school?
Yes, sir.
Okay. Was he out during this period of COVID? Was he out of school for a period of time?
Yes. In New Mexico, we were in online school up until just a couple weeks ago. They did just reopen the buildings, and he's loving it. School bus picks him up from the driveway. He's excited to ride the school bus and meet kids. It's been a tough year, him moving here during the COVID. You know, he didn't have the ability to meet kids. But now that he's in the classroom, he's loving it. At first, the online school was a little difficult for him. You know, as a second grader, he was expected to keep track of his own assignments and know how to log in online and make sure he's doing stuff. But around Christmas time, we got through that, and the teachers have noticed significant improvement.
Now, was there a period of time in his prior school that he was enrolled in some special education classes?
Yes, sir. He got flagged in the state of Texas for an emotional disturbance from his mother, and was in a special education program there. When he enrolled here, that program transferred to New Mexico, but they wanted to do their own evaluation of him. So after, a couple months ago, probably January, February of this year, they had the school psychologists and counselors meet with him and meet with me, and they've deemed that he no longer has an emotional disturbance, and they removed him from the special education program.
Okay, so he's doing quite well there.
He is.
Okay. What other activities is he involved with other than school?
Nothing really extracurricular yet. Over the winter, we snowboarded a lot. That was kind of our thing. Kids get free season passes, so every weekend we'd kind of go snowboarding. That was his physical activity. We're kind of waiting. New Mexico just went green, so I'd like to get him enrolled in sports, some basketball or something. I'm 6'6", so I think he'll be a pro someday. Right now, we're still, school's going to end shortly, and we'll kind of figure out something for the summer for him.
Okay. Are you employed currently?
Yes, sir. I think last time I was unemployed due to COVID. I worked in the entertainment industry. I've since been rehired at my original salary, and thankfully we made it through. So I am gainfully employed again.
All right. Now, when we were here back in July of last year for temporary orders, Ms. Domingue appeared pro se. You recall that hearing?
Yes, sir.
And she was given some periods of access. I want to say 2 15-minute video chats per week. And then she was ordered to pay child support. Is that accurate?
Yes, sir.
Okay. Has she been consistent with her communications with Damien?
No. She seems more interested in talking to me than the child. I gave her a window. I was working through the winter part-time at a snowboard rental shop, and I worked till 7:30 every day, and his bedtime was 8:30. So I told her, I was like, you have 7:30 to 8:30 is your 1 hour window any day of the week. And instead she'd call me in the middle of the night or in the middle of the day in the workday. And at first I would answer thinking it was an emergency, and she wanted to talk to me. She wanted me to help her with her family drama, or me to send her money, or me to do this. And there was one time she called Damien and said, "Hey, I need to talk to your dad." And I said, no, talk to him first. She talked to him for 2 minutes and then just hung up the phone. And he even looked at me and said, "Well, that was weird. I hope she's okay."
Well, do you have any idea where she's living or if she's employed?
Currently, my understanding is she's homeless. She's been unemployed forever. She got evicted from her apartment, or her husband divorced her. She got evicted from her apartment. My understanding is she was jumping from women's shelter to women's shelter. She has significant mental illness. She just got released last week from a 21-day involuntary psych hold at Griffin Memorial Hospital in Norman, Oklahoma. And my understanding is that when she left, the doctors there thought she would not take her medicine. So they gave her a shot with like a 20-day dose. And since then, she's been back in the women's shelters. She's been through 6 phone numbers. I never have a way to get a hold of her unless she wants to get a hold of me from gas station cell phones and strangers' cell phones.
Okay, so in the last month, you said she's had 6 different phone numbers that she's called you from?
In the last year, it's been about 6 different cell phone numbers that she had, let alone gas station phones, strangers' cell phones. I'll wake up in the morning with missed calls at 2 a.m. from a random Oklahoma City number. And when I call them back the next day, they say, "Oh yeah, some girl borrowed my phone last night."
Now, there was prior testimony about her having been in an auto accident with Damien in the back seat of the car. Do you recall that?
Yes, sir.
What do you know about that?
I don't know much. He wasn't in my custody at the time. I know it was in Texas. The airbags deployed. It did total the vehicle.
Are you familiar with a report out of Hutchins Police Department whereby Ms. Domingue was contacted officers about some kind of problem that she was having?
Yeah, that was something that turned up in one of our subpoenas. She was found hitchhiking from Oklahoma City to Dallas. And I guess the lady that picked her up started getting quite uneasy with her halfway through the drive and just left her at a gas station in Hutchins. And she called the police needing assistance, I believe.
Claimed she was raped by somebody that lived down in Coolidge, Texas.
Correct. Yeah, she claimed sexual assault. I think they said they had her analyzed and didn't see any evidence of a sexual assault.
Okay. And Judge, we've got about 25 exhibits, and I know a lot of these are ones that we offered and had admitted at the temporary orders hearing. Is the court familiar with those?
Let's see. There is something. We can go off the record for 1 second, so I'm not just babbling. there's something in the court's file that says it's addressed to me. It says confidential, and it's coming from. I don't even want to. It's coming from somewhere in Conroe. Was that? Didn't we have an issue with a subpoena, motion to quash?
Yes, we
Okay.
did. We did, Judge. That was from a mental health facility, I think, in Conroe. I believe that's right.
Okay, it's sealed up and okay, but that's not what I was thinking it was probably exhibits, but we can go back on the record and you may proceed. And Mr. York, to answer your question that led to me recessing for a moment, I've got the exhibits here, but if whatever you, some were not offered and some were and admitted, but do whatever you'd like.
Okay, thank you. I'm going to go ahead and show a video here if I can get it to come up. This is a video I believe that was played last time. We've marked it as exhibit number 24. I'd like to go ahead and offer and publish it to the court at this time.
It's admitted.
You know I gave you this little DNA card to give you a reminder of I love you. And thank you.
Okay, do you recognize that voice, Bradley?
I do. It's sad. At my house, he doesn't speak that softly. It's kind of sad to see that in him.
Well, the female voice, do you recognize the female?
Oh, yeah. Sorry. That is Brooke. Yes, sir.
Well, what is this white substance on the floor, if you know?
I believe it's salt.
Okay, so he's confined to that circle?
Yes, sir.
Okay.
She thought he was possessed and placed him inside a salt circle.
I'm going to offer what's, let's see, marked as exhibit number 25 in evidence.
25 is admitted.
Do you recognize, Bradley, do you recognize that as your son and Brooke Domingue in this video?
Yes, sir.
It appears that she's screaming at him.
Yes, sir.
How does that make you feel?
Not good.
All right. Let's see. I'm going to show you what's marked as respondents exhibit number 1. Can you see that on your screen?
Yes, sir.
Okay, just go over it just for a minute, make sure you understand it and have read through it. Have you been through it?
Yes, sir.
Okay, is this what you're asking the court to grant as your relief on final hearing in this case?
Yes, sir. We had spoke about using a different platform for the 15-minute visits. Your Honor, the problem I'm having, sir, is she contacts me neurotically at crazy points in the night. She's always calling me, threatening me, texting me that she's going to sue me and my family, that people are out to get us. I would like to minimize my contact with her. Mr. York had mentioned that there was like a secure web platform that we could do the visitations on so that she wouldn't have to have access to my cell phone number.
Well, let me clarify something. I'm not familiar with a secure video or chat where she can talk to the child verbally. I'm aware of Our Family Wizard and App Close that will allow for communications, text communications between you and she.
Okay. Sorry, I was unclear on that.
Okay. So, and I think what you told me is you didn't think she would abide by that, or you think that everything that she contacted you about would be considered an emergency affecting the child. So it really wouldn't be beneficial.
Yeah, she likes to play emergency. You know, she'll call me in the middle of the night because she wants someone to talk to, and she'll say, "Oh, people are out to get Damien. There's bad people looking for him. Lock your doors, keep him safe." And I lived a state away from her, but she creates emergencies just specifically to get a hold of me and harass me.
Okay, I'm going to offer respondents number 1 as an aid to the court at this time.
Respondents 1 is admitted.
So this looks like respondents number 21. Is this a text exchange between you and the petitioner in this case?
It's a message she sent me. Yes, sir.
Okay. Is this typical of how?
Sorry. This message is something she sent her previous husband, Ryan, that he forwarded to me because it was regarding Damien.
Is this something that is typical in your communications with her?
This is the way she communicates. Yes, sir. Okay. It's usually jumbled. It doesn't make a ton of coherent sense, and there's a lot of threats and anger in them. Yes, sir.
Okay, I'll move to admit respondents number 21 in evidence.
It is admitted.
Okay, Ms. Domingue was ordered to pay you child support and medical support. You recall that?
Yes, sir.
And how much has she paid you since the temporary orders?
Nothing.
Nothing at all?
$0.00.
Okay, so she's not financially supporting the child. She's not physically exercising any visitation because she can't, and she's not even using what the court gave to her last July. Is that right?
Correct. I mean, she has spoken to him briefly here and there. It's nowhere near the 2 calls a week. I mean, I would say 1 every couple weeks. And honestly, the visits she does have, you know, it takes a toll on him. He doesn't miss her or get sad or cry about her until after he talks to her.
Okay. So you think he's functioning well enough in your care?
Absolutely.
And you don't think she ought to have any more visitation? Actually, she should have less because she hasn't used what she's been allotted. Is that right?
Yes, sir.
Okay. What you're asking for in your requested relief, do you believe this to be in the best interest of your son?
Yes, sir.
Are you asking the court to approve it?
Yes, sir.
Thank you. I'll pass the witness.
Anything further?
Yeah, I'd just like to approve attorney's fees, Judge.
You're an officer of court. You may proceed.
All right. My name is Robert York. I'm an attorney licensed to practice law in the state of Texas. The counter petitioner retained me to represent him in this suit affecting the parent-child relationship. He retained me back in 2020. I was charging him a usual hourly fee of $350 an hour. And at some point towards the end of last year, the rate increased to $400 an hour. The novelty and difficulty of the questions involved in this particular case for attorney's fees required that I spend, not including today, 13.25 hours for a total of $5,125.11. Expenses were billed separately, and the expenses total $537.61. I believe these fees are reasonable and necessary considering matters of this type, an attorney with my reputation and ability. Pass myself.
Based on the testimony, I will grant the relief that's been requested, finding that the relief that is being requested is in the best interest of the child. Certainly, the relief as far as visitation, video visitation between the child and the mother seems to be in the best interest of the child, and hopefully the mother will take advantage of that when she gets a copy of this order and is able to review it and continue with all her other obligations that have been ordered. But until that time, that'll be the order of the court. That concludes this hearing. Mr. Myers, I wish you all the best, and hopefully Ms. Domingue will exercise her visitation and not make it so traumatic on your son. But that sounds like a ways to go at this point. So.
Thank you, sir.
All right.
Thank you, Judge.
Where were you snowboarding, by the way, out of curiosity?
We live in New Mexico, so we were doing kind of Taos, Angel Fire, and Sipapu.
Okay. Yeah, I went there this past March with my kid and family and went to Red River, and
Okay.
we just skied. The snowboarding looks interesting, but that's for other people to do, not me. So,
Yes, sir.
all right. Well, good luck to you, sir, and enjoy this. Well, I guess skiing's over with for the year, but it'll come back shortly.
Yes, sir. Thank you, Your Honor.
Thank you, Judge. Are we excused?
Yes, sir. Have a good day.
You too. Thank you.
So that's it till 11.
Looks like it.
So McCain, the 11:30 McCain is off, and then we have one of the 11:30, yes, and then 11 a.m. is still on. Okay. All right, we'll be in recess.
Okay.
Well, I'm looking for Mr. Johnson.
Your Honor, I can tell you, I have not spoken with Ms. Bedard, but Cedric and I did have an opportunity to visit about the case last week, but I just assumed he would be here.
Okay.
I can text him real quick.
Yeah.
And Judge, while we're waiting for that, I did file a motion to consolidate today because there's a prior OAG.
Yeah, I saw it in the petition. It was mentioned the previous order.
So I filed that for that case to be consolidated into this divorce case.
Okay. Well, let's see if Mr. Johnson.
Oh, yeah. Okay, excuse me 1 minute.
Okay. Oh, I was just looking at something else. Are you Miss Cook? Can you unmute yourself?
Got it.
Yeah. Your attorney is Mr. Johnson. Have you heard from him this morning?
No, I have not.
Okay. You knew about this hearing though, obviously, because you're here. So.
Yes, I had multiple reminders set up, plus I got multiple email reminders.
Okay. All right. Well.
I wonder if he might be in another setting, like another court downstairs or in the county court of law. But
I'm not sure.
While we're waiting, Judge, perhaps I could visit with Miss Keithley and she could update me on the agreement that she has with Mr. Johnson.
Okay.
or the issues in dispute.
Okay.
One or the other.
One or the other, or all of the above.
Yes.
If we were live, we could just step aside and into a little room, but.
Well, and you're, okay, there's two Keithley. I'll put you to Sarah Keithley. There's Mr. John or somebody now.
Oh.
I'll put y'all all in the breakout room.
Okay.
Yeah,
Is
but
this room something I'm supposed to join?
no, just, and if Mr. Crawford, or, I mean, Mr. Johnson, Miss Bedard, and Miss Keith, they're all in a breakout room. If Mr. Johnson would join that room.
Okay. This is all so weird.
It is.
Okay. 229 7014. You'll send me one to whatever you'll have it. Yeah. Here's the screen messes up or something. Save it. Or text it.
Yes, I'm about to
Okay, got it.
text you.
Okay. So keep with me. If something on the screen happened or whatever, just text me. I'll keep it with me. I'll be back and forth.
Hey.
Okay, did y'all have an opportunity to talk? Y'all had to unmute yourself.
Yes, Your Honor.
All right. Well, let's go then on the record in D21-29636-CV. And this is in the matter of the marriage of Brianna Rose Cook and James Boulware in the interest of James Ray Boulware Jr. and Ellie Mae Boulware children. I have the parties present, council's present, and seems like before we went on the record, Ms. Bedard, you said you had filed a motion to consolidate. Is that correct?
That is correct, Your Honor, because there is a prior Attorney General order in cause number D19-27926-AG that was signed in 2019.
Okay.
I filed the motion to consolidate that case into this divorce matter.
All right. Any objection from either Ms. Keithley or Mr. Cook?
No, Your Honor.
Johnson? I'll get the names correct.
No, Your Honor, no objection to that.
All right. And then we had temporary orders set. Was that correct?
Yes, Your Honor.
All right. Do y'all want to give opening statements?
Yes, please.
Okay.
Judge, I'll waive my opening.
All right. You may proceed.
May it please the court and counsel. Your Honor, as the court in our pretrial discussions has been made aware, back in 2019, with the lead of the Attorney General's office, this married couple entered into a child support review order wherein the Attorney General's office was involved in negotiations and custody, conservatorship, possession and access, and child support were established. It's my understanding, I believe the evidence will show the parties were married in 2015, they separated in 2018, and then in 2019 with the Attorney General's assistance, they set up the framework for what we're going to be presenting to the court today. I believe the evidence will show recently the parties have filed for divorce, and I believe the evidence will show that since 2018, both parties have engaged in extramarital relationships. They both have paramours, they both have children outside the marriage. And so we're going to be cleaning up, hopefully with this lawsuit, their lives so that they can start independent lives from each other. I believe the evidence will show the two children for the past 3 years around about have had a split custody relationship with the parties. I believe the evidence will show last year, towards the end of last year, the parties entered into an agreement where they would have custody of the children during the week. The father has conservatorship of the boy, the mom has conservatorship of the girl, and then the children are together every weekend. It is our position that on final trial, the father would like to have full custody, but here at the temporary basis, I don't believe there's any affidavits that have been filed or any extraordinary circumstances that would warrant changing the custody arrangement on a temporary basis. So we're asking the court to, adopt the Attorney General's conservatorship possession arrangement with the exception of, and I believe the evidence you will hear evidence about what the parties have agreed to and have been doing since October or November of last year, as far as the possession time with each parent, and most importantly, the children's time that they are together. Thank you.
All right. So before we go any further, let me go ahead and grant the Attorney General's motion to consolidate. And any other opening statement?
No, Your Honor.
And none from the state.
All right. Can we do this in 15 minutes aside?
Yes, Your Honor.
Yes.
Okay. All right. You may call your first witness.
And I would call Brianna Cook.
Ma'am, if you could raise your right hand and unmute yourself. Okay. Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Okay. You may proceed.
Brianna Cook, you're the mother of these two children, correct?
Yes.
All right. And what's their names and date of birth?
My son is James Ray Boulware Jr. He was born on January 16th, 2012. My daughter is Ellie Mae Boulware. She was born on May 13th of 2014.
So they're 9 and 7, soon to be 7.
Yes, she will be 7 in just a few days, and she's growing too fast.
Okay. And so you heard the opening statement of Ms. Keithley in regards to there being a prior Attorney General case and there being some orders related to the children, correct?
Yes.
All right. And you were present and party to that, correct?
Yeah. Yes, I was.
All right. You're that same Brianna Cook, correct?
Yes.
All right. And you were named as the primary or the parent or conservator with the exclusive right to designate the primary residence of the children in that order, correct?
I do believe so, yes.
All right. And
they didn't exactly spell it out for me.
I got you. And during that time, have you maintained the residence in Nevada County?
Yes.
All right, and at the time y'all agreed to a 50-50 schedule where y'all alternate weeks, correct?
Yes, he would do Friday to Friday, 5:30, and then I would get them Friday to Friday, 5:30.
Okay, and how would that schedule work for you?
For me, it was fine. I had no issues with it.
Okay, so why did you guys change to some other schedule where he has the son primarily and you have the daughter primarily?
They they kept complaining about it's not good enough. They don't need to do this.
So was
Trying
it,
to say it wasn't good.
all right, was that something that you agreed to?
Is I didn't agree that it wasn't good for them. I mean, they got to spend time with both parents at the same time together for a full week, and then vice versa.
All right, has that schedule created some disturbances for the child?
Not to me, it didn't. I mean, they were doing fine.
Now, I'm talking about the new schedule that
Uh,
now.
oh yeah, yeah.
Now, what's the issues that you have with the new schedule that your husband has tried to implement?
For one, my kids aren't together all the time like they should be. Brother and sister should be there together all the time. There's nothing more important than having your sibling with you, having them to talk to.
And is that why you guys agreed to split the time equally 50-50 so they could spend that time together?
That's why I agreed to it.
Okay. So is that part of the reason why you're asking that this court order that schedule be put back into place, the alternating weeks?
Yes,
All right.
that's one of the reasons.
And what's your other reason for wanting that schedule to be put back into place?
Well, when both kids are here, they have a better opportunity to see all their family. I have a big family. I have 3 sisters and a lot of nieces and nephews, plus my parents. And they also get to see their aunt and their cousins from his side of the family when they're with me. But when they're over there, they really don't get the opportunity to do any of that.
Okay. Now, the 50-50 schedule, who's primarily with the children when he has them during that 50-50 schedule?
His girlfriend, Brittany Jackson.
Okay. So that was one of the issues you had with the week on, week off schedule, correct?
Yes.
All right. And is that part of the reason why you think you should be named as the primary parent of both children?
Yes.
What's the issues you have with Miss Jackson and her parenting style in regards to your children?
Well, she I know my daughter, it's like making them do something they don't want to do. My daughter really doesn't like to have her hair put up. She'll agree to a ponytail every now and then, but over there she does like crazy hairstyles where there's a bunch of rubber bands put in her hair, stuff like that. That breaks the hair, it hurts the head, it makes the scalp burn. And my daughter has come home from over there with the same things going on, with all the rubber bands. I have to cut them out of her hair.
And is that something you've explained to Miss Jackson that she shouldn't do to your daughter's hair?
The very first time I actually spoke to her was when I still lived in the apartment me and my husband had shared.
Here, you got to get straight to it. Have you talked to her about doing that and told her not to do that?
I have once before, and
did she continue to do it despite you telling her?
Yes.
Are there
She
other
still does.
examples of things like that where you tell her as a parent not to do something in regards to your children and she just disregards those things?
I mean, I never really get to talk with her because she talks at me. If you understand what I'm saying, like it's hard to get a word in with her.
So have you attempted to have these conversations with her, telling her not to do certain things in regards to the children?
I've attempted, yes.
All right. Is the painting of your son's fingernail, is that an example of that?
Yeah, I mean, we spoke about it before through text messages and whatnot, and she has said that it's something that he wants. And I told her I'm totally fine with it if it is something he wants.
Now, have you spoken to your son about that? Is that something he wants to have his fingernails painted?
Sometimes he'll tell me yes, and sometimes he'll tell me no. I mean, he's a kid. It flip-flops. But before any of this, he didn't like that stuff.
All right, so is that something that you believe his conduct that he's now adopted, and that's because of Miss Jackson?
Well, I wouldn't know if it's because of her. I mean, if you look at it in the point of the view of he's a small boy, his parents had split up, things changed for him, so he's changing.
Okay, well, that's another example of some conduct in which Miss Jackson is more involved in making parenting choices and not Mr. Boulware.
I know it's her that speaks to my son's, I'm guessing it's his therapist. I know when they called me, it was always a nurse. It was never the actual therapist.
All right, and
I know my son has told me he doesn't get to speak to her.
are these things that you think one of the parents should be making decisions on and not his new girlfriend?
Yes, I believe that if it comes to any type of doctor's appointments, whether it be dental, primary, or therapy, it should either be me or his father.
All right, and do you think he just allows Miss Jackson to take responsibility for these things during the weeks that he has your children?
I do. I think he does it because he either can't take time off of work or just doesn't want to.
Okay, and so that's why you would be asking for primary to be able to make those
Yes.
decisions and do those things. All right, and where do you work?
Me, I don't work. I have been a stay-at-home mom for 9 years.
Okay,
I have done nothing but take care of my children.
and you have other children other than these two with Mr. Boulware?
I have one son that is not his.
All right, how old is that son?
He is a year.
Okay, and are you still with the father of that child?
Yes, I am.
Okay, and so y'all have been split for a while, correct? You and Mr. Boulware?
Yes.
All right, so there's no property that's at issue here. Everything that belongs to you, you have, and everything that belongs to him, he has, correct?
Yes.
Okay, and where does Mr. Boulware work?
I believe they're still called the Lago de Plata Apartments.
What does he do for them?
He is a maintenance man.
All right, and are you asking, as the court orders you primary of both of their children, that he be ordered to pay child support based off his income?
Yes.
Right now, there's an offset amount of child support, correct?
Yes.
All right, but you're asking if you're awarded primary possession of both children with a standard possession order, that you be given just a standard amount of child support.
I wouldn't care if it changed any. It could stay the same. It could even drop a little bit.
Okay, and the medical.
Because to me, that really doesn't matter.
How are the kids covered for medical insurance?
They both have Medicaid.
Okay, and right now he's ordered to cover the cost of that. Are you asking that he continue to pay that?
Yes.
Okay, I'll pass the witness.
Ms. Keithley?
May it please the court. Ms. Cook, you indicated, you testified you do not have a job. You are not disabled, is that correct?
No, I am not.
And you do not have a driver's license, is that correct?
That is correct.
And so if you make these doctor's appointment, you're going to have to coordinate with the father or some other person that has a driver's license to be able to transport your children to these doctor's appointments you're talking about. Is that correct?
Yes, ma'am.
You've not filed any type of affidavit making any allegations of any type of abuse or neglect at this particular junction in the lawsuit. Is that correct?
That is correct.
And you've indicated that you want to have both children in your possession and you're seeking more child support. Is that correct?
I'm not seeking more child support. Like I just told Mr. Johnson, I could care less if it even went down some because it's not about the money.
Gotcha. All right. Thank you. I'll pass the witness.
All right. Ms. Bedard? Any questions?
No questions, Judge, actually.
Mr. Johnson, you wanted to ask something?
Just a couple more questions, Judge. Who would you use to coordinate for transportation, to and from those doctor's appointments?
I've got a list of people.
All right, name.
My mom.
Okay, where does she live?
She lives in Mildred.
And then you also have a sister who lives close?
I do. My sister, she also lives in Mildred.
All right, what's
I've
the,
also got my dad who lives in.
okay, so you have means to, you have a young child right now. You have means to get that child to and from any kind of necessary appointments, correct?
Yes.
Okay.
Just the other day, I took both my kids to the dentist.
Would it be appropriate in this case if there was some kind of like app used to communicate between you guys? Like a Family Wizard or App Close? You're on mute.
What was that? It cut out.
Yeah. Are you asking the court to order that y'all communicate through an app like App Close or Family Wizard? That way the court can see the communications between you guys?
Oh, yes.
You know, you're asking that login information be only given to Mr. Boulware and not his girlfriend, for her to communicate through that.
Yes.
Okay. Has there been a situation in which his girlfriend attempted to assault you?
Yes.
And when was that? And kind of describe the circumstances.
That was on Christmas Eve the year before last. I went to their apartment to pick up my children, and she came outside carrying a baseball bat. She was trying to get into, I don't know if she was actually trying to get into the truck or just, talk at my boyfriend through my door that was open on the passenger side. So I shut it. That made her angry and she started going off. At the time, I was pregnant with my youngest son, and she shoved me in my face twice.
So are you asking that she not be involved in any kind of pickup and drop offs?
That's exactly what I'm asking.
Okay. Would this whole situation be a lot better if not for Miss Jackson?
I believe so, because there have been times where when he has brought the kids here just by himself, he's cordial, he's not rude, he speaks. But when she is with him, he doesn't talk.
And do the kids pick up on this?
I'm not sure if they do or not, but I'm pretty sure they do. Kids are very smart. They pay attention. That is how we all learn growing up. We pay attention to what is being done around us.
All right. Are the kids ever forced to come back and relay messages that Miss Jackson has relayed for you?
My daughter has told me on occasion that she has told her to come home and call me fat and tell me I'm a bad mom.
All right. And did your daughter actually do those things?
No, she does not. She just tells me that that's what she was told to do.
I got you. I'll pass the witness.
Ms. Keith, any questions?
No, Your Honor.
Ms. Bedard?
No questions, Judge.
Okay. Any other witnesses, Mr. Johnson?
No other witnesses. We rest.
All right. Ms. Keithley?
Yes, Your Honor. I call James Boulware.
All right, sir, if you could raise your right hand. Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may proceed.
Your name is James Boulware, is that correct?
Yes, ma'am.
And Mr. Boulware, you are the father of Brianna and James Jr., is that correct?
Ellie Mae and James Jr.
Ellie Mae and James Jr. Now, you and Miss Cook, your wife, entered into an agreement to change the paperwork that the Attorney General gave y'all back in 2019. Is that correct?
Yes, ma'am.
And was that roughly around September of 2020, September of last year?
That's when it was going to take effect.
Okay, and you guys had made that agreement prior to that?
Yes, ma'am.
All right, when you made that agreement and the school year started, how was your daughter enrolled and how has she been attending school this year?
She's been doing the at-home learning through Corsicana ISD website.
And what about your son?
He, starting in September, he started going to in-class schooling at Navarro Elementary in Corsicana.
And have you heard any information from Ms. Cook, any complaints about how your children are doing education-wise?
No, I have not.
Do you, have you been provided any information why the education designation should be changed right now?
I see that it should be changed because, I mean, everything's opening back up, and I think she would get better learning and better schooling going to in-person.
Just the socialization aspect of it, is that what you're saying?
Yes, ma'am.
All right, going to the possession schedule, when you made the arrangement to, I guess, change the week on, week off, when did you and your Miss Cook start talking about that?
I believe it was in July or August.
And the you implemented that in September. Is that a fair statement?
Yes, ma'am.
Leading up to that, when you were in discussion with Ms. Cook, did she have any reservations about your girlfriend spending time with your children, or how the children would feel about changing the time that they were spending with each other and the time they were spending with each parent?
I'm going to object to that question as far as speculation.
I'll sustain.
Mr. Boulware, when you and Ms. Cook were communicating about changing the 2019 Attorney General order, did she have any reservations or objections to changing the custody arrangement?
Same objection, Your Honor.
I didn't hear your objection, Cedric. I apologize.
Just object that his response requires speculation.
Well, he may respond if she told him something, but if it calls for speculation, then he may not answer. How's that for a clear ruling?
That's good.
Go ahead, Your Honor.
Sir, you may respond if she told you anything in regards to the question that Ms. Keithley's asked you. If it calls you to speculate, then you may not answer.
She didn't have any objections to me doing that.
When you and Ms. Cook were discussing changing the amount of time that the children spent with each other and in each parent's house, why did you feel that that was in your son's best interest to live with you and in your daughter's best interest to live with the mother primarily?
Both the kids were saying that's what they wanted to do, and Miss Cook was just fine with it as long as the child support stayed the same. She didn't want to lose that child support.
And when your son came to be with you during the school week, and your daughter, went to live with the mom during the school week, and the school year's been going on, have you noticed any problems with the children?
No, I have not. They've been seem to love it. My son loves living with me, and my daughter, she seems to love living over there.
We have about 3 or 4 more weeks of the school year. Is there any reason that you can see that would be appropriate to change this custody arrangement that you and the mother agreed to 8 months ago right now?
No, I do not. I think it should stay like this to finish the school year at least.
Now, for the past 4 summers, or I guess 3 summers, you and Ms. Cook have had a shared custody visitation for the summertime. Is that correct?
Yes.
And what do you do during the summers?
Last summer, it was the week on, week off. This summer, we wanted to do 2 weeks on, 2 weeks off.
And have you heard any objections or any reasons why that should change for this summer?
No, she was completely agreeing with me like 2 weeks ago, saying that she was okay with doing the 2 weeks on, 2 weeks off.
And then if in the event that we are still in this lawsuit and school starts again in August, is there any information, evidence, reasoning you can provide to this court that we need to change the temporary, relationship that you have with your son and Ms. Cook has with her daughter when the kids start school?
No, I do not.
And as far as when it comes time for them to get back into school next year, you want both of them to be in person. Is that a fair statement?
Yes, ma'am.
Now, we've heard some allegations about your paramour, your girlfriend, interacting with Miss Cook. Let's talk a little bit about her paramour. Do you know that her boyfriend's name?
His name is James Burns.
And has James Burns had interaction with your children?
Yes, they have.
All right. Are you concerned with the way that James Burns treats your children?
Yes, I am.
Now,
And I have brought this to her attention several times.
Okay. As far as Mr. Burns biting or hitting your children, are you asking the court to do a temporary injunction for Mr. Burns not to hit or bite your children?
Yes, ma'am.
As far as interacting with Mr. Burns, is there any violence or problems with you and Mr. Burns?
No, I try not to go around him because the things he has done or said has made me mad, and I don't want to do something I would later regret.
Miss Cook had a story to tell us about an incident that happened at Christmas Eve 2 years ago, or I guess 2.5 years ago, between her and your girlfriend. Do you know if there's been any police reports called about that incident?
The police were called, but they really just took a statement from each side and said that they both hit each other, so there was nothing they could do. They both shoved each other, so it was just, that was it.
You and I have gone over the court's standing order and the basic premise that during this lawsuit that there's not to be any fighting or breaching the peace between any of y'all. Are you asking that same rules or prohibitions be extended to your girlfriend and her boyfriend, so that all of the adults in this case are not acting inappropriately, especially in front of the children?
Yes, ma'am.
All right, I'm going to show you what I've marked as petitioner's exhibit number 1. You want to share my screen?
Yes, ma'am.
Can everybody see that?
Yes, ma'am.
Okay. All right, Mr. Bulware, in front of you, you have the requested relief. Is that correct?
Yes, ma'am.
And for the benefit of the record on this hearing, you've asked that you and Ms. Cook remain temporary joint managing conservators. Is that correct?
Yes.
As far as the rights and duties go, you're asking that the residency restriction that's in place to Navarro County be expanded to Navarro and contiguous counties. Is that correct?
Yes, ma'am.
Do you have any plans, or do you know if Ms. Cook has any plans to move immediately?
I do not.
Okay. As far as the education decisions go, you are asking that either that be something that you be responsible for, or that the children attend school in person as opposed to over the internet. Is that correct?
Yes, ma'am.
And as far as our temporary custody situation goes, you're asking that the court approve and adopt the temporary arrangement that you and Ms. Cook entered into in September. I guess it implemented it in September of last year. Is that right?
Yes, ma'am.
As far as what how the children are doing in school, how they're faring medically, emotionally, is there any reason to change what you two have been doing all of these months?
No, they both seem to be very happy with it.
In the alternative, are you asking that the court allow both children to reside with you and visit with the mother on with a standard possession order?
Yes.
As far as temporary child support, if the court changes the possession, are you asking that the court award you child support, have Ms. Cook pay you child support?
I don't want no child support, just the Medicaid.
Okay. And the cash medical reimbursement, you've been paying that, is that correct?
Yes, ma'am.
And if you get temporary possession of both children, you want her to pay that, is that right?
Yes, ma'am.
And as far as temporary property and temporary debt, as Mr. Johnson, I guess, pointed out on his direct examination, you guys have been split up for a long time, but everything in your possession will remain in yours possession and everything in Ms. Cook's possession will stay in her possession. Is that correct?
Yes, ma'am.
Do you feel that this is in your children's best interest as far as keeping the conservatorship and visitation arrangement the way it's been for the last several months?
Yes.
Your Honor, at this time, I would offer Petitioner's Exhibit 1 as an aid to the court.
Any objection from Mr. Johnson or Ms. Bedard?
No objection, Your Honor.
It's admitted as an aid.
All right, I'll pass this witness.
All right, Mr. Johnson.
So where do you work?
I work at Silver Lake Apartments in Corsicana, Texas.
What are they called?
Silver Lake Apartments.
Okay. Is that the same as Lago de Plata?
They switched owners, so it got a new name.
Gotcha. Did you get any kind of change in pay when they changed ownership?
Actually, I got rehired a few months ago, and when I got rehired, they did increase my pay.
So how much do you make?
$17 an hour.
And how many hours do you work?
80 hours every 2 weeks.
And you get paid bi-weekly?
Yes, sir.
Okay. What hours do you work?
Monday through Friday, 8 a.m. to 5 p.m.
All right. So you keep saying that we made these agreements in regards to the children, but those weren't really agreements. Those were things that you just did, and because you just did them, she had to just kind of follow what you were doing, correct?
No, she didn't have to follow what I was doing. She agreed to it.
After you had already did those things, though, correct? Like after you had
No.
out of the Carroll School and put him into Navarro?
No, that was later, after the agreement was already made.
Okay. So.
And I have text message proof.
Like this is a written agreement that you guys came to?
We made it over text message. I have the text messages printed.
You have those with you today?
Yes.
Okay. All right. So did you also tell her you were going to be taking the child and moving to Waxahachie?
No, I did not.
Are you aware that your new girlfriend has been communicating that y'all going to take the child and move to Waxahachie?
No, they have not.
Okay, so no one's ever made that statement that y'all going to take this child and move to Waxahachie?
It's never been said that we were going to take the child and just move away. We have talked about that maybe one day we will move to Waxahachie.
Okay, so there is some discussion.
But I still have a whole year lease at my place that I'm now, and I don't break my lease.
All right, but there's been discussion that you're going to move to Waxahachie.
That I could possibly move to Ennis or Waxahachie, yes.
So she's not just making this up?
No, I've said that it's a possibility that I could move to one of those two places.
All right. I got you.
That's why in my relief, I wanted contiguous counties.
Why do you allow your girlfriend to put your son on dresses and paint his fingernails?
That is stuff that he is asked to do. He's asked us to buy him dresses and put paint on his fingernails. And with him being a kid, if he wants to do that, then I'm going to allow him to do that. So it's just him expressing himself as a child.
If he told you he wanted to go out and buy a gun and play around the house with the gun, you'd let him do that too?
No, because guns are not for children to play around with. We take extraordinary measures with the guns that we do have, so that way he cannot touch them, cannot play with them.
But you understand, as a parent, some decisions, some choices, it take an adult to analyze certain choices.
But him wanting to dress up and play, that's perfectly fine. But a gun, that's just a whole another direction.
All right. Did he come to you and say, "I want to get my ears pierced too"? Or was that something?
Yes, he did.
You allowed him to do that because he wanted to do it?
I did.
Wow.
I have my ears pierced, and I got them done at a young age, and there's nothing wrong with me having my ears pierced.
How old was he when he came to you and said he wanted to get his ears pierced?
He was 8.
All right. And
he said for his birthday, he wanted his ears pierced.
I got you. So do you allow her sons, to put on dresses and paint their fingernails too?
Yes, actually, one of them, he does. He sees that James Jr. is doing it, and he thinks that it's cool, so he wants to do it, and we let him do it just as well as I let James Jr. do it.
Okay, so you got a bunch of boys over there running around in dresses and painting their fingernails.
Yeah, if they want to do it, I mean, it's not hurting nobody. They seem perfectly fine.
You allow them to wear these dresses to school too?
No, because it is uniforms only.
Okay, all right. Other than that, you would allow them to just put on fingernails?
If he wanted to wear it to school, then yes, I don't see nothing wrong with it.
All right. And is that something you discussed with the mom to see maybe whether or not she's okay with that?
No, I have not.
All right. So now when it's mom's turn to have him and she doesn't want him to wear dresses and put on fingernails, do you see how that creates an issue for mom?
I mean, she could talk to me about those things. She's never once brought it up.
All right. You just never hear it when she brings it up, right?
No, she's never brought it up.
All right.
I've never deleted a text message from her. I keep all that as a paper trail. She's never said nothing.
All right, I got you. So what if your daughter wanted to shave off all her hair? You'll just allow her that to happen as long as she wants to do it?
If she wanted to do it and it's not hurting nobody.
Got you. All right, I'll pass.
So is there something against bald women, like cancer patients? They don't have no hair. They have no choice.
Thank you, sir. Thank you.
Any other, Ms. Bedard, any questions from this witness?
Yes, Your Honor. Mr. Boulware, how many other biological children do you have besides these two children in this case?
Just one.
One other biological child?
Yes,
How
ma'am.
old is that other child?
He is 18 months old.
Okay. And he lives with you and Miss Jackson?
Yes, ma'am.
And do you have private health insurance available to you through your job at Silver Lake Apartments?
I do believe so.
And do you know how much it would cost to enroll these children on your insurance that's available through your job?
I do believe it's more than I get paid.
Can you clarify that?
I have no document with me right now. But
Okay.
I could get with my job and see how much it costs.
Okay, so do you have an idea? Is it 500 a month, 1,000 a month, 300 a month? No clue whatsoever how much it might be?
I believe it's 700 and something just for one child.
Okay. Now you understand that if the court were to modify the orders and name you as the primary conservator, and the children both now start living with you, and they no longer live with with the mother, Miss Cook, she would not be able to maintain the Medicaid because the children would no longer be in her household. Do you understand that?
Yes, I could switch them over to Medicaid through me.
Okay. Have you ever attempted to do that to see if you qualify?
No, I have not.
But to go ahead and apply, and if the court were to modify these orders and name you primary and the kids live with you, you'd be willing to undertake that responsibility to go and secure health coverage for the children?
Yes.
Pass this witness.
Any other questions of this witness?
May I ask a couple, Your Honor?
Yes.
Mr. Boulware, Ms. Cook, your wife, is receiving government benefits. Is that correct?
Yes.
She's in subsidized housing through the government. Is that correct?
Yes.
Food stamps through the government. Is that correct?
Yes.
And do you have any idea, since if she's claiming your son is residing in her household, to get those benefits? Do you know?
I do not know. I have not asked her that.
All right, I'll pass the witness.
No, nothing further.
All right. I guess at this point, I'll take closing arguments.
Judge,
I'm sorry, Ms. Bedard, do you have any witnesses to call? Sorry.
No witnesses for the state judge.
I'll take closing.
I would first like to point out that even though this was filed as an original petition, there is a prior custody order in place that the court will be modifying. And as far as my pleading showed, Ms. Keithley hasn't filed anything that would show that there's a significant impairment that would allow the court to change the primary designation for temporary orders under 156. So we would point out to the court that short of there being an affidavit that alleges significant impairment on behalf of the respondent, the court can't grant the relief that Ms. Keithley is requesting, in which her client is named as the primary parent of either child, because the prior order does name my client as the primary parent of both children, with the right to designate their primary residence in Uinta County. Judge, what we're asking for temporary orders is for the court to award, is to continue to award her that primary right, but for both children, and to implement a standard possession schedule more in line with the right that she's been given under the previous order, where dad gets a standard possession order. I think the parties were intending or had good intentions in agreeing to the week on, week off, where both parents got to have equal amounts of access to the children. But for children of this age, it just doesn't work when there's a huge difference in parenting styles, and where the kids are disrupted by the exchanges and the amount of time. Clearly, the parents here have a different parenting style, where Mr. Bolwer is just willing to allow the kids to do whatever they request of him, which, you know, is more typical of a dad with a weekend possession. They just want to have fun with the kids and, you know, enjoy all the time to spend with the kids when, you know, they're not their primary parent. But he's doing that on a basis that affects how the kids behave when they're with mom. Mom doesn't allow the son to dress in dresses and paint his fingernails and pierce their ears. Mom wants a more stable environment for the son and for the daughter, and they're not getting that at the dad's house. So we're asking the court to award just a standard possession with standard child support, allow the parties to communicate through app close or some other app, because, you know, I guess there has been an issue with the new paramours with both husband and wife. So we asked that there be no communication at all allowed by those people. And we'd ask that they not be allowed to be at the exchanges as well. But we feel like this is what's in the best interest for these kids on a temporary basis. I think right now the testimony is that both parents live in Corsicana. There would be no disruption of the child's education with awarding dad a standard possession. Mom has the ability to get the kid to and from the school that they're currently enrolled in. So we're just asking for the court to just kind of stabilize the situation a bit that's become unstable based off that week on, week off possession.
Thank you. Ms. Keithley?
May it please the court and counsel. Your Honor, I think it's always compelling to understand and look at these cases through the eyes of the child, and in this case, the children. And this is most unusual because we've already have a SAPSR order that's been set up. We've got the parties who have worked together to reach an agreement that was in the best interest of their children almost 8 months ago. And now we're faced with a divorce, and the mother has now changed her mind about how she wants to treat the situation. I think it's fundamentally unfair if we only recognize what the mother wants in a situation and not take into consideration these children's lives. In this particular instance, for an entire school year, we have two children that have lived in separate homes and have visited each other. We have no evidence from teachers. We have no evidence from doctors. We have no evidence from therapists that there is anything wrong with these children and wrong with the way that they have been parented by each parent up until this point. The mother may have changed her mind. She may not like certain things, but she dang sure hasn't done anything about it in these several, in this entire school year for sure. And now she's up here complaining about her son expressing himself in ways I'm assuming she or her attorney feel are inappropriate or they don't like it. First of all, this court has a obligation, hopefully, to do what is in these children's best interest. To fundamentally change the time that they're spending with each parent would be very detrimental. And I would hope that this court would not do that without some type of testimony from a mental health expert that would enlighten all of us as to how these children are being damaged by having a very solid relationship with both parents. If we are checking the moral check card, this is a very unusual family. We've got paramours, we've got other siblings, half siblings, and it's a very, I guess, modern family, if we're going to call it that.
But what's most important in this lawsuit is how these children are faring right now. We have 2 children that have survived a pandemic. They have been educated appropriately. They've been educated appropriately. They have been loved appropriately. And now the parents are not communicating and the mother has filed for divorce. It is in the court's realm of possibilities to reduce the amount of time these children spend with their father and to, I guess, penalize the father by making him pay the mother more money, and to penalize the father to reduce his access with his children. But what I think would be in the children's best interest, and what Mr. Boulware are asking you to do, is to codify through your order what the parties have been doing since September of last year. And I guarantee you, if Ms. Cook had a problem with how this has been transpiring, then she could have taken actions prior to this year to come before this court and tell the court the woes that she's experienced. We feel it's in the best interest of the children for the children to remain with the parent that they have been residing, that being the son primarily with the father, the daughter primarily with the mother. The children are with each other, and this goes on for 4 more weeks. And then when summertime rolls around, I believe school releases June the 4th. At that point, then the parents have a expanded or extended summertime visitation that they've already agreed to. 2 weeks with mom, 2 weeks with dad. We'll work out that through the summer, and either we'll reach an agreement or we can come back and have a final hearing and figure out custody on an ultimate basis. But I asked the court, no matter what the morals are in this particular equation, and the morals of all of us in this court hearing are, it is most important to look at this through the eyes of the children. And there's no evidence, there's no reason to change what the children have known for 8 months now. They seem to be thriving. The evidence before the court is there is no problem. It's just the mom's changed her mind. And she has a right to do that, but she should not do that to the detriment of her children. And we ask the court to keep everything the way it has been and allow this family and really the lawsuit to progress so we can do our discovery and find the evidence we need to show the court what is ultimately in these children's best interest. Thank you.
Ms. Bedard.
Your Honor, I've made some calculations for support for the multiple scenarios. I don't know if the court has any interest in those numbers or if you'll do your own calculations, but I wanted to let you know that I have those numbers if you'd like.
I'll tell you what, if I decide that I want to, I will issue a letter to all parties asking for those. Thank you.
Yes, Your Honor. Yes.
And Mr. Johnson, anything further?
Just so I get the last argument on the motion, Your Honor, I would just say that the agreement was for a week on, week off schedule. So we're not talking about the parties living up to their agreements. The dad wouldn't unilaterally change the agreement to take primary possession of the son. And my client, unemployed, had mustered up enough money to hire someone to come and say, that's not what I agreed to, that's not what I wanted. Though it took some time, she was able to do that. And that's why we're here today. It's not because she agreed to this change and where dad gets primary. It's because dad did it, and it took her a while to get the legal resources to come and say, hey, no, that's not what I agreed to. That's not what's working for my children. And this is not a case where I don't think either party has the means to go out and hire a bunch of experts to say what the kids feel or what they think the kids are expressing. But we do have a mom who knows her kids well enough to say, no, wait a minute, that's not what my kid likes to do. Someone's influencing that behavior of my child. And so that's why we're here, Judge. And I think those are the kind of things in this type of case that needs to be taken into consideration. What the parents know from their kids and what their kids are expressing it in. We may not be able to get, a bunch of experts on this case to come and tell the court what their clinical opinion of these issues are, because for one, I don't think my client will be able to afford that. But my client is testifying today that there's issues that the stepmom is ultimately raising a child when the child's at dad's house, and that their parenting styles are completely different and they're not suited for a week on, week off schedule any longer. So that's why we're asking for the standard possession, Judge. We're asking you to deny their relief based off them not meeting the requirements of 156.
All right, I'll take this under advisement. I would hope the parents maybe will consider in the interim the having a boyfriend and girlfriend during the pendency of a divorce. Sometimes it seems like those come too soon, and so, but not for further discussion at this point. But
Thank you, Judge.
with that concludes this hearing. Thank y'all.
Thank you, Your Honor.
Have a good day.
You too.